Good morning. My name is Andrew Danis. I'm a partner with the Washington, D.C. law firm of Jaskiewicz and Cobert, and I have the privilege of being the co-chair of the EALG network of international law firms. This morning, I'm going to be presenting a monthly webinar that the EALG does for its members. And by way of background of the EALG, we're a network of independent law firms based in the United States, Europe, South America, and Asia. We do annual meetings, biannual meeting as well, next week in Cyprus, and webinars and topics on legal issues through the course of the year. Today, I have the privilege of speaking on drafting and enforcing contract choice of law and jurisdiction clauses in U.S. cross-border transactions. It'll be about a half-hour webinar, and hopefully you will find it interesting. Now, the importance of choice of law and forum clauses in contracts with multinational parties cannot be denied. It's something that can actually be crucial to a litigation and determine whether or not the litigation is actually resolved, whether or not the litigation will be resolved in the forum that the parties, or at least one of the parties, wants the forum to be resolved in, and frequently can be dispositive, especially in the United States. One of the things to bear in mind about the negotiation of choice of law and choice of forum clauses is that they may not actually be negotiated. These are clauses that, in careful drafting of a contract, an attorney would pay attention to it, but frequently dispute resolution is something that is considered at the end of a litigation, not a litigation necessarily, sorry, but at the end of a contract drafting. What are we going to do with the dispute? When you're drafting a contract, usually you're looking for a positive relationship in the future. Sometimes it can be contentious and you can do an arm's length negotiation. But frequently, choice of law and forum selection clauses are items in contracts that either are incorporated by reference through a standardized form document, through other legal documents or standardized terms. Let's say a course of dealing where a contract requires a transaction that requires another document, and that document may also contain terms and conditions. Sometimes they're on the internet, and they're internet terms and conditions that have what you might call hidden form selection clauses, or alternatively form selection clauses that are not freely negotiated. Now, one of the things I'm going to do in today's webinar is discuss some of the background of a litigation that my firm recently handled out in Sacramento, California, in the federal district court out there, by way of an example of how forum selection clauses and choice of law clauses can be a part of a litigation, but secondly, in some cases, resolve a litigation or be fairly determinate. Now, the case is Rangdong Joint Stock Company versus JF Hildebrand USA, Blue Eagle Consolidation Services, GmbH. My firm represented the defendants. The lawsuit was filed at the end of 2018, and the case was recently dismissed in August of 2022. During this 3-year time period where the case was being litigated, the defendants never filed an answer to the complaint. Subject matter of the complaint was something that was always involved in the case, and obviously before the court, but the jurisdictional questions and the contractual provisions were the provisions that actually were the subject of the litigation. At the end of a 3-year period, the court determined that the case against the German defendant, legal, had to be resolved in Germany due to a contract clause. The court had asked for briefing on co-defendant U.S. agent, U.S. company, also had to have the claims dismissed, but the defendant voluntarily dismissed them. So By way of example as to how these disputes work on a practical basis, the Rangdong case involved a shipment of wine from Northern California to Vietnam. Rangdong went to the U.S. company based in California. It's a Delaware corporation, New Jersey headquarters, but they also operate in California, and asked for a quotation on how to ship the wine, how much it would cost to ship the wine to Vietnam. Blue Eagle, the company that was German company, was actually a carrier that was going to handle the transport of the goods as a carrier, but the quotation and the coordination and all of the other aspects of the transactions that were subject to the litigation were by the U.S. agent. The plaintiff alleged that what happened in the shipment was that it was supposed to move to a particular port terminal in the city of Ho Chi Minh, port of Ho Chi Minh City in Vietnam, but instead it went to the wrong terminal. It was about 30 miles away, and that it took 8 days to arrange for the goods to be transported to the correct terminal, or the allegedly correct terminal. During that time period, the wine was basically cooked in the heat of Vietnam in March of 2018, and it was up to $500,000 due to excessive heat. Now, obviously, all of these claims were disputed by the defendants, and the court never actually took a look at the real merits of the claim. Instead, what was litigated was whether or not the dispute was actually going to have to be litigated in the courts of Germany, or whether or not the court in Sacramento could take a look at it. Now, the practical basis for defending the case and moving the case to Germany was there was a bill of lading, and the bill of lading is a type of contract. And that bill of lading said that the terms and conditions of the bill of lading govern the transaction. The plaintiff received a copy of that bill of lading, but never received, which said terms and conditions on the back, but alleged that it never received the back of the bill terms. The defendant's position was as well, the terms and conditions of the bill of lading usually were on the back, usually were given to the customer. Also, they were published on the, and they were published in documents that were available to the plaintiff and which were required to be published under U.S. federal law. However, the plaintiff claimed that it never received a copy of the contract, wasn't bound by the contract, and that German jurisdiction and law over the claims violated U.S. laws. The plaintiff also claimed that it could also sue for negligence, and in addition to suing for breach of contract and breach of a U.S. statutory provisions that applied in the transaction, that the plaintiff could sue, in particular, the U.S. agent under a theory of negligence in both booking the contract allegedly to a wrong terminal and then failing to address the situation in Vietnam. Again, I need to emphasize that all of the claims of the plaintiff are highly disputed, that the defendants said that the goods were shipped to the right place and that nothing had been done in action. So that's the scenario. That's the type of situation where you look at a contract clause and you say, okay, here's a contract, here's a dispute. The dispute involves both breach of contract claims, alleged breaches of U.S. law, and also alleged breaches of common law duties and duties under the common law for performing services in this case. How do they get resolved? What's the rule in the United States? Now, there are some courts around the world that will not enforce form selection clauses, or alternatively look at them skeptically. In the United States, that used to be the case as well. In the United States, form selection clauses can be challenged for lots of reasons. One of the reasons being it's inconvenient to bring the suit. In the chosen forum, the forum didn't have any connection to the litigation. And that was the general proposition for years. Now, about 40 years ago, the United States Supreme Court started changing that. And in this slide, you'll note that it says the U.S. is the signatory to the Hague Conference on Private International Law, Convention on Choice of Court Agreements, which is a recent agreement, basically treaty on how to enforce and when to enforce choice of forum clauses. But the reality of it is it hasn't been implemented yet. And in the United States, federal procedural law generally governs the enforcement of choice of forum clauses in contracts. And I want to emphasize here that while the basic principles I'm discussing are principles that would apply in many state courts as well, let's say you brought a lawsuit in Georgia or you brought a lawsuit in California, in the state court, I'm primarily discussing federal court cases here, in part because federal courts are frequently the chosen forum or the chosen place of litigation when foreign parties are involved. Now, the basic federal rule on choice of forum is that choice of forum clauses are prima facie valid and are generally enforced. A major case on this is a U.S. Supreme Court case in 2013 called Atlantic Marine Construction Company versus U.S. District Court for the Western District of Texas. The fact is that there's a number of other earlier cases that also have that general proposition and move the court in this direction. But Atlantic Marine is the major case and pretty much the definitive case at this point in time. The fact that the foreign selection clause is contained in a forum contract does not necessarily prevent it from being enforced. One of the complaints about forum selection clauses, as I mentioned at the start, is that's not the result of necessarily the result of an arm's length negotiation. What it might be is something that's in a forum contract. The Carnival Cruise Line case, which is from 1991, involved basically a ticket with a forum contract, saying that disputes would be resolved in the chosen forum. The company that issued the standard forum contract. And what the courts in the United States basically say, the Supreme Court in particular say, is that the need for uniformity for large corporations in particular to know that they have a uniform forum that's going to interpret basically contracts with similar terms and in a general location so that the case doesn't have to be, various similar cases don't have to be litigated piecemeal in various parts of the world or various parts of the United States, means that, there's a presumption that you should go ahead and enforce these contracts. And that just because it's a forum contract doesn't necessarily invalidate the contract. Now, taking a look at choice of law clauses, in the United States, choice of law clauses are generally enforced in the same manner as the choice of forum clause. A couple of key issues tie into this. One is that issues of mandatory U.S. public policy may come into play in the public policy provisions of a choice of law, may trump or defeat the selection of the choice of law clause. In addition, the courts may imply a choice of law clause in a choice of forum clause. I have a slide coming up that discusses the Atlantic Marine case again, which is the Atlantic Marine says. And that could be enough on a public policy grounds to defeat a choice of forum or choice of law clause. One thing that becomes very important is that there may be hidden sources of a choice of law clause. So, for example, one hidden source is that if you have a contract that doesn't address choice of law, you draft a contract, it doesn't address the law that actually is going to apply, but it does have a choice of forum, and it says that the law may be transacted the case may be litigated in that jurisdiction, you may end up with a choice of law on a de facto basis. When you're in the litigation in the United States, the Atlantic Marine case comes up with a criteria on challenges on the enforcement of a forum and whether or not a case should be transferred or dismissed, because basically it's not a convenient called forum non convenient. And the basic proposition is that there's a contract provision that says the case should go elsewhere. And what the Supreme Court says in the United States is that forum selection clauses should control except in unusual cases. So it's the exceptional case where a court will not enforce a forum selection clause. Again, as I said earlier, that didn't used to be the law in the United States, but it clearly is the law now. Arguments of private inconvenience of a party, which used to be a very frequent defense to the enforcement of a forum selection clause, have been waived because they were foreseen at the time of contracting. So, for example, you take a look at litigation in California that involved a shipment of wine from Napa Valley to Vietnam, but the German carrier was saying that the contract involved required litigation of the dispute in Hamburg, Germany. So the plaintiff can argue that, well, this is not going to be a convenient factor for me to litigate a case in Hamburg, Germany. My contract is here in California or over in Vietnam. However, the Supreme Court has said that no, that was foreseeable at the time that you contracted. Even if it's a forum contract, it's foreseeable. If you had notice of the contract and the contract behind you to it, then yes, you're not going to be able to make that argument. The court may consider public interest factors. Public interest factors may be a way to defeat the application of a clause. And in making the determination, one of the other factors the court needs to look at is that the law of the contracted forum will apply in the event of a transfer. So what that means is, in particular, if you have, let's say, choice of forum clauses in the United States, where the litigation is in New York, but it's going to go to Georgia because the forum selection clause says that, then law of Georgia needs to be applied. Unless there's a specific clause in the contract that says choice of law applies. What the Atlantic Marine case says is that, no, you need to take a look at the factors there. And what that also means is that the court needs to examine, let's say you file a lawsuit in New York, but the defendant says, no, you need to go to Germany, or you need to, let's say, go to Georgia. The court in New York needs to take a look at the law of Georgia in determining whether or not there are reasonable basis and grounds to enforce the contract. So you get into situations where the parties are in a dispute and the court has to take a look at the law of the jurisdiction. Now, there are hidden conflicts and choices of law. One aspect of that in the United States in particular is that a federal court in the United States actually has a number of sources of law. Let's say that you argue that New York law applies. Well, New York has local law peculiar to the particular site of the court. It has New York law, which is the general statutory and common law of New York. Then there's going to be federal law. Federal law may be mandatory U.S. statutory law, or alternatively, there may be international treaties. International treaties are the U.S. is a party to are a form of mandatory binding law that would arguably trump lower levels of law. You also need to take a look at substantive laws versus procedural laws. The fact that you have a case where the litigation needs to be under, let's say, the laws of Germany, but procedural laws of the state of California are the governing of statute of limitation purposes means that you might have a case where the statute of limitation that applies is the statute of limitation of California as opposed to the statute of limitation of Germany, depending on whether or not it's a procedural law. So if a contract doesn't have a time bar, or if a contract's clear on this issue, that is something that would need to be taken a look at. Now, in the particular litigation we were handling, there was a federal statute that had a statute of limitations, and that was basically a one-year statute of limitations. So the lawsuit had to be brought within that time period in the United States. That was a mandatory law as well. It was mandatory U.S. law. However, the other claims that were in the case are claims that would be governed by common law or state law. And then the question would arise as to whether or not you have to take a look at German procedural law, if German law applied, or depending on the party and whether or not the party was bound by the procedural law, whether or not the procedural law, if a statute of limitations is a procedural law of the state of, let's say, California, would apply. Now, one of the other things to keep in mind with hidden conflicts of law is that it's not always apparent when a law is going to actually not be applied or not the same. For example, the Convention on the International Sales of Goods is a treaty that has been enacted in approximately 93 countries. The U.S. is a party to it. If there's a counterparty to the treaty, then that convention applies as a matter of law over other laws that might apply. There's a similar law in the United States called the Uniform Commercial Code, which governs the sales of goods as well, which has similar but slightly different terms. And so if you had a contract that said it's governed by New York law, the fact is that if there's a contract party that is in another country, let's say Germany, the Convention on International Sales of Goods might apply in lieu of the New York Uniform Commercial Code. Similarly, if you have a contract that says that all disputes will be resolved under the laws of Germany, again, if Germany has the Convention on the International Sales of Goods, and this happens to be a transaction involving the buying and selling of goods, then arguably you don't have a real conflict of law issue because the same law should apply. But that leads to another point, which is the interpretation of law, whether or not the laws will be interpreted in different courts. Now, one of the issues that frequently comes up, and it came up in our litigation, is whether or not the chosen forum will effectively go and apply the law, or whether or not they can applying a law will end up with a violation of a mandatory U.S. law. If there's a mandatory U.S. law that applies to a transaction, then if moving it to another country means, or another jurisdiction means that the law will not be enforced or not necessarily properly interpreted, then the choice of law or the choice of forum clause may be defeated. In our case, there was an argument that there was a U.S. statute that applied, and it was a mandatory statute. And even though it was based on an international treaty, the courts of Germany did not interpret that treaty in the same manner as the U.S. did, and that there were certain causes of action available in the United States under U.S. law that weren't available under German law or in Germany. And we had expert witness testimony come in from German attorneys to this effect. Now, the court never addressed that issue. It never reached that issue to resolve it. And when the case went to another round of litigation on the issue of forum selection, the plaintiff didn't proceed to raise that issue again. Under Atlantic Marine, it's some of the arguments may not be as valid. The contrary aspect of it is that U.S. courts have held that the particular statute at issue can be easily interpreted by German courts. And also in the case that we were litigating, there was provision in the contract, and the provision in the contract stated that U.S. law, this particular U.S. statute, would apply to the transaction because it involved states. So what some federal courts do when they're confronted with this issue is they take the mandate that the case needs to go to the foreign country, but they may retain jurisdiction so that if there's an issue that occurs, uh, let's say that the plaintiff who filed suit in the United States suddenly has to go to the foreign country, the plaintiff has the right to come back to the U.S. court and say they didn't apply the law correctly. And that's not necessarily a review on whether or not the court actually reached the correct decision, but more a question of whether or not there was a fundamental issue of U.S. law that was not properly enforced and that violated public policy. Now, one other aspect to keep in mind is that sometimes, in particular, there are international treaties involved that govern the subject areas. If the foreign country actually has legal standards that may be higher or more beneficial than the U.S. legal standard, that means the court can look at it and say, well, that's not an excuse not to send it overseas. So it's always best to draft a contract where the contract actually addresses these issues, that removes ambiguity. But if not, again, it needs to be kept in mind that unless the court is fairly certain that you're not going to get U.S. law applied and effectively applied by the jurisdiction, the case is supposed to be transferred. That's what the Supreme Court says, and that's generally what happens nowadays. Now, scope of the clause. This is a drafting issue. Enforcement of a clause really depends on the language that's used in the contract. Is it mandatory or permissive? Those are may or shall situations. Is it exclusive or non-exclusive? So if a contract says that all disputes should be resolved, may be resolved in Hamburg, Germany, that's different than a contract clause that says all disputes shall be resolved in the courts of Hamburg, Germany, where the parties agree, which the parties agree have exclusive jurisdiction over the claims. One other issue to keep in mind is that the scope of the forum and subject matter jurisdiction is that in the United States, at least, a court cannot exercise jurisdiction over a contract claim or a claim in a contract where the parties say, we agree that all litigation is going to be in this court, if the court doesn't have jurisdiction over it on other bases as well. So the claims in the United States in the federal court, a claim must be brought in the federal court because either there's a federal law involved or there's a diversity between the parties. One party is domiciled in one region and another party is domiciled elsewhere, and the amount in controversy exceeds a threshold amount. If you have a contract dispute where the parties are in two different locations, but that contract dispute is below the jurisdictional threshold, you can contract and say the court, the federal court in New York is going to look at this, but the federal court may decline jurisdiction because it will say, well, I don't have a contract, I don't have jurisdiction over this for diversity purposes or the amount in controversy, and there's no federal claim involved. In the litigation we were handling, there were federal claims involved in addition to breach of contract, negligence claims, which leads to the next point, which is the contract language inclusive of all claims or just contract claims? If you have a contract that says that all matters arising from a breach of contract is subject to the exclusive jurisdiction of the courts of Germany, that doesn't necessarily mean that all other claims that are related to the transaction are subject to that exclusive jurisdiction because it's a breach of contract claim. On the other hand, if you have a contract that says all claims related to or arising from this contract, whether brought in contract, arising in contract or court, shall be brought in the courts of exclusive jurisdiction in Hamburg, Germany. That means that anything or is subject to the interpretation that anything that happens within the scope of the transaction, the business transaction, may be subject to that clause. Now, in the case we had a very broad clause that said all of those claims. It also said it applied to agents and subagents, but that leads to the other point, which is non-contract third-party litigant rights may be an issue that affects how you're going to bring the case and whether or not the contract clause will be enforced. One way that forum selection clauses can be unenforced or not enforced is if a party that is seeking to enforce a forum selection clause brings a cross complaint or a countersuit against a third party who wasn't a contract party but is part of the transaction. Let's say you have a banking transaction or a letter of credit transaction, and two parties are having a suit over certain parts of the transaction, but the third party is also brought into the case, and there are cross claims that are brought against them. That third party may not be subject to the litigation or subject to the mandatory forum selection clause. And then the court needs to make a decision as to whether or not it can transfer part of the case, whether or not it's going to transfer all of the case, or whether or not it's going to say to the parties, no, you need to litigate it here. We have jurisdiction, and this forum selection clause is not going to be applicable because it may violate, let's say there's a statute involved that may violate U.S. policy of everybody. So the basic rule in the United States is third-party rights. Contractual choice of law clauses cannot ordinarily be enforced against third parties who are not parties to the contract. Under some circumstances, you can bind a third party. Let's say they're closely related to the dispute. If the dispute was foreseeable that they would be bound, or agents, successors in interest, let's say an assignee or someone that bought a party, or third-party beneficiaries to the contract, they may all be bound by the forum selection clause. But again, it requires an analysis. So let's go back to the practical aspects of it, and I'll wrap up this presentation. So in our shipment of wine from Napa to Vietnam, we had an agent in the United States that negotiated a contract on behalf of another party, but the plaintiff claimed they were also a party to the contract. You had a German company that handled the shipment as a carrier, and they claimed that they had a contractual provision in a bill of lading contract that they said governed all the terms, but the plaintiff said, no, we never received that. We never saw those terms. We never saw it on the internet. We weren't informed about it. And then you have claims on negligence that are actually non-contractual claims that the plaintiff was alleging primarily against the U.S. agent and saying that the case needed to be against them. So the court went and dismissed. In May of 2022, the court dismissed the claims against the German company. What it found was that in negotiating the contract, the terms and conditions of the bill of lading, which the plaintiff says it never received and never saw, were also published in a government document, which the plaintiff was given a rate quotation, and the rate quotation said that if you ship or if you agree to make a shipment under these terms, or this price quote, you're going to be subject to the terms and conditions, and those terms and conditions that are published on this particular published government document. And the court found that that was enough to give notice. And even though the plaintiff said that it never saw those terms and conditions and really didn't know that they existed, the court said, no, that's enough notice that you actually knew about the contract. And therefore, you're bound by it, the case goes to Germany. But then the question arose, what do you do with respect to the other party to the case, the U.S. agent that negotiated the contract and did so on behalf of the German company? They were claiming they weren't a contract party, but they were claiming that they were a beneficiary of the contract. The negotiated document said that it was acting only as an agent, and the actual terms and conditions of the negotiated document had a provision saying it would apply to its agent. So the court asked the parties to brief the issue as to whether or not the claims against the U.S. company could stay in the court or whether or not they also had to go. The issue was briefed, and once it was briefed, the plaintiff voluntarily dismissed its claims against the third party, non-contract party, was not explicitly a party to the contract, just acting as an agent on the contract. And with that voluntary dismissal, that ended the lawsuit. Now, the argument would be that any lawsuit that had to be brought really did have to go to Germany. That's clearly the position of the defendants. But it illustrates how the third party rights all get intertwined and can go and affect how both you enforce a forum selection clause and enforce a law clause. But in addition, can affect the outcome of litigation. As I said, over a 3-year time period, there was quite a bit of litigation in this case over whether or not the court was supposed to actually be the right place for the litigation. Ultimately, the court said no, the case needs to go to Germany. And that was pretty much the end of it. So in conclusion, a couple of quick points. Number one, drafting dispute resolution clauses and choice of laws clauses should never be an afterthought. It is always something that should be looked at. Secondly, any form contract or any contract that incorporates by reference other documents. If you're an attorney, you should take a look at the other documents. If you're a business, you should take a look at the other documents and be aware that other documents may determine where your disputes are going to be resolved. And what the Supreme Court says is you really need to make a hard and fast decision as to whether or not you want to do business with a company if a dispute occurs and that dispute is going to be resolved in a forum so that you don't want to be engaged in. Finally, you should recognize any contract party should recognize that whether or not you want the business transaction and the deal, you need to take a look very, very carefully as to how the deal is structured and recognize the fact that third parties may be involved as well. So let's say you're going to have a contract between two parties, but other parties are going to be involved in the case. And those other parties may be involved in litigation. You need to examine the fact as an attorney or as a business, well, if I'm going to actually have this, am I going to have 2 litigations or 3 litigations? Because the fact is that it may be that one party to a transaction has a document that says you're going to litigate in point A under the law of point A, and another party may say, no, you're going to litigate our claims in point B under the laws of point B. And that can lead to very interesting legal issues as to, well, what do you do when you're the company that's bringing the lawsuit, but you need to sue the company with A, and you also need to sue the company. That's the topic of a much more complicated webinar, and we'll save that for a future one. Again, I'd like to thank everybody for attending and listening to this, and I hope that you attend future EALG webinars on a monthly basis. Thank you very much. I appreciate it.